What is the quorum?
Good afternoon. If it please you. My name is Mutula. I'm on record for all of the petitioners. Mitula. I appear together with Ms. Wanjiro for the petition.
With?
Ms. Wanjiro for the petition.
I'm on record for the first and second respondents.
Yes.
It is the court Mboko. I do appear for the third and fourth respondents.
Answer for the fifth respondent. Good afternoon, my lord. May I have the permission to address this court? My name is Ruto and I was counsel for the intended interested party who represent 43 public universities. I have thought that the certificate of urgency had merit and therefore would have been given directions and therefore been admitted before today. And therefore we seek that you guys were to be admitted.
At this stage? At this stage?
My lord, matters were dire within my clients' institutions, and therefore they instructed me to move under certificate of urgency to enable to unlock what was then put in that I be permitted to be part of the quorum.
You want me to place you in the quorum?
Yes, my lord.
Just that?
For now, and maybe we can be able to assess the merit in due course. I don't know if you are able to peruse and review the application that was filed on behalf of my clients.
You notice I'm not recording because I'm trying to find out where to place you. Yes. So, did you serve the application on parties?
My lord, I have not been given that because I did not receive any directions from the e-portal, and therefore I did not know what the court stand was on this matter. And I've shared with my learned friends when we are just seated. Yes.
What is their view?
Maybe
Petitioners further argued that the new funding model is also discriminatory in the sense that students under the age of 18 will not get funding. The respondents countered, contending that a circular had been issued that no student should be denied funding on account of age and that students under 18 years be allowed to use their KSC index numbers. The respondents undoubtedly admitted that the petition's contention is correct. The circular, if any, remains a circular. There was no logical explanation why such a recommendation was made, what it was intended to, and what it was intended to achieve. The recommendation remains, and this court cannot be persuaded by a mere promise and a hope that the recommendation will not be implemented. It is discriminatory to use age as a basis for treating students differently, as age is one of the prohibited grounds in Article 27, Article 4 of the Constitution, and cannot be allowed in a democratic state. The new funding model may also bring about unintended consequences on the choices of courses. Students not being sure of the categories in their hierarchy of needs they will be placed may opt for less costly courses, thereby allowing only those financially able to take courses that cost more and usually prestigious, creating an imbalance in favor of the financially few, thereby thwarting dreams of many students. Article 43, Article 1, Clause F of the Constitution is plain that every person has the right to education, a socio-economic right the state has an obligation to respect and protect. As already alluded to, education being a public good, the government has a positive obligation to ensure that Kenyan students have access to the courses they desire without hindrance through prohibitive policies. The new funding model exhibits such prohibitive tendencies which may not be allowed. I agree with the petitioner, therefore, that some of the recommendations and measures contained in the new funding model are discriminatory and violate the Constitution. The other issue is the legitimate expectation. The petitioners again argued the new funding model violates students' legitimate expectation. According to the petitioner, students expected to get funding through the differential unit cost funding model and loans from the Higher Education Loans Board. They relied on, among other, the decision in Communication Commission of Kenya versus Royal Media Services. The respondent denied violation of legitimate expectation. They contended that under the new funding model, students are made aware of the cost of the courses and units in each university during selection of courses and units so that they are aware of the cost at that point. The fifth respondent also stated that its portal has this information for the benefit of students as they apply for placement. Students who have been subjected to the new funding model sat for their KSC examination in November, October 2022 and applied for university courses and placement then. The applications for placement were based on the old funding model and had expectation that they would be placed under the fund and funded under that model. The Working Party was appointed in 2022 and submitted its report in June 2023 after students had applied for placement. The recommendations had not been made and the students could not have been made aware of the cost of the courses and units in universities when they made the application. The fifth respondent's argument that this information is on its portal for the benefit of students as they apply for placement cannot be true, as the new funding model was only brought to the public attention sometime later. It is therefore true that the students who sat for KSCE in 2022 October-November examination made their choices based on the old funding model with the expectation that they would be funded through the differential unit costs and loans from the Higher Education Loans Board, the funding model in law. In the Communication Commission of Kenya, the Supreme Court talked of an instance where legitimate expectation would arise. It's when a body, by representation or by past practice, has aroused an expectation that's within its power to fulfill. Can also see some decision there from South Africa and Canada. Adverting to the legitimate expectation in Keroche Industries, the court stated legitimate expectation is based on not only on ensuring that legitimate expectation by parties are not thwarted, but on a higher public interest beneficial to all, which is the value or the need of holding authorities to promises and practice they have made and acted on, and by so doing upholding responsible public administration. The court emphasized that legitimate expectation enables parties affected to plan their lives with a sense of certainty, trust, reasonableness, and reasonable expectation. Students had chosen courses and units on the foundation of the then existing model and had planned their education based on the certainty of the differential unit cost funding model and loans from the Higher Education Loans Board. The certainty of the funding based on the law is based on the law and is still in place, lifted their expectation as they planned to join higher learning. The abrupt and unexpected change through the introduction of the new funding model violated their legitimate expectation and the planning, which was also based on the law, and the government would fund 80% of their education through the differential unit cost model and the higher loan loans board would fund the difference. In that regard, public participation legitimate expectation was violated. The last of the point is public participation. The petitioner again took issue with the new funding model, arguing that it was not subjected to public participation in violation of Article 10 of the Constitution. In the petitioner's view, once the report was presented to the President, recommendation on implementation of the new funding model should have been subjected to public participation. The respondents maintained that there was public participation during the formulation of the report, and therefore there was no need for another round of public participation. Public participation is a founding value in our Constitution. Article 44 sub-article 2 identifies Kenya as a multi-party democracy. It's a multi-party state founded on national values and principles of governance in Article 10. Article 10.1 then provides that national values and principles of governance bind all state organs, state officers, public officers, and all persons whenever any of them applies or interprets the Constitution, enacts or interprets any law, or makes or implements public policy decisions. Article 10 is the heart and the soul of our nation. The principles in this article bind every person whenever, among others, they make or implement public policy decisions. The argument by the petitioners was simple, that the report, more so its implementation of the new model, should have been subjected to public participation before being implemented. The respondent countered that there was public participation at the initial stage, and therefore further public participation was unnecessary. Article 10.1 is clear that the principles in Article 10.2 are bind every person whenever formulating or implementing public policy decisions. The Working Party took public views to enable it to come up with a report. The report made certain recommendations, some of them legislative. The recommendations that are of legislative nature will be subject to public participation while bills are prepared and tabled in Parliament. Recommendations which appear to be of policy nature should have been subjected to public participation. The new funding model, as recommended, has the effect of touching on the law and should have been subjected to public participation to allow people to give their views, even if it is for its improvement, before implementation. This will also give Kenyans not only information about the funding model, but also opportunity to comment on it and its implications before implementation. Although the word used in Article 10.1 is makes or implements public policy decisions, implementing a public policy with the fundamental consequences to the people's lives requires people's input before its implementation. In this decision of Kiambu County, says Robert Gakuru, the Court of Appeal acknowledged the primacy given to public participation and stated, this one I quote, the issue of public participation is of immense significance considering the primacy it has been given in the supreme law of this country and in relevant statute relating to institutions that touch on the lives of the people. The Constitution in Article 10, which binds all state organs, state officers, public officers, and all persons in the discharge of their public functions, highlights public participation as one of the ideals and aspirations of our democratic nation. In Minister for Health, there's a South African decision which you see there. The Constitutional Court of South Africa observed that a reasonable opportunity is to be offered to the people, to members of the public and all interested persons to know about the issue and to have an adequate say on it. The essence of public participation is to allow people an opportunity to have a say on issues that touch on their lives. An issue as emotive as the new funding model and which fundamentally affects people's lives should have been subjected to public participation. The views given before the working party were intended to enable the team come up with a report and recommendations. It was the recommendations that were to be implemented without going through a legislative process like the new funding model, which were to affect the lives of the people that should have been subject to public participation. There is no denial in this petition that the recommendation on the new funding model was not subject to public participation, despite the drastic and fundamental shift in the funding of higher education in the country. Implementation of the new funding model without public participation violated the principle in Article 10 of the Constitution. The respondents argued that despite the petitioner's fears on the overall implementation of the funding model, there is an appeal mechanism so that if one is not satisfied with the level of need assigned to him or funding, he can appeal. As already pointed out earlier, this funding model is not anchored on any law. The body to which appeals lie is unknown, its composition is unknown, and so is its procedures. It can be an ad hoc body that may decide appeals arbitrarily, capriciously, and at whims. It may also be subject to abuse. This is not a guarantee that all will be well, where lives of millions of students are affected, yet there is a certainly working funding model, however imperfect it may be perceived to be. In conclusion, having considered the petition and arguments by parties, I come to the following conclusions. First, the new funding model violates the law, namely the Section 53 of the Universities Act. The section identifies differential unit cost as a funding model with the funds allocated by Parliament among other sources. The new funding model provides for a specific sharing of higher education funding without onboarding it to statute, thus introducing the funding model through a policy in conflict with the law. Second, the new funding model is discriminatory in some respect, introduces classes based on perceived financial ability, discrimination among students based on type of school a student attended, whether private or public, and introduces age as a factor in assessing funding, and introduces a non-term called household income as a basis for accessing funding. All these violate Article 27 of the Constitution. Third, the new funding model violates legitimate expectation of students and their families. Current groups of students chose universities, courses, and units based on the differential unit cost and the loans from Higher Education Loans Board, but found themselves confronted with the abruptly introduced new funding model that they were not aware of. Having planned their lives, their university affairs based on the old funding model, the abrupt implementation of the new funding model is a violation of their legitimate expectation. Fourth, the new funding model was not subject to public participation despite its fundamental effect to the country's education system. The implementation of this new funding model also bypassed parliamentary oversight in violation of Article 95 and Article 5B of the Constitution. Based on the above conclusions, the court makes the following declarations and orders. A declaration is hereby issued that implementation of the variable scholarship and loan funding model as currently stands contravenes Section 53 of the Constitution and the mandate of the Higher Education Loans Board and is unlawful. A declaration is hereby issued the variable scholarship and loan funding model is discriminatory and violates students' legitimate expectation. A declaration is hereby issued the variable scholarship and loan funding model is unconstitutional for lack of public participation. An order of prohibition is hereby issued prohibiting implementation of the variable scholarship and loan funding model until the government complies with constitutional and legal requirements where necessary. This being a public interest litigation, each party shall bear their own course, and that is the judgment.
To make an oral application to stay your judgment dated 20th of December 2024. Your Lordship, for the following reasons. The first and second respondent, Your Lordship, already rolled out the program termed as the new funding model. Your Lordship, the second respondent funds...
Which respondent?
The second respondent, Your Lordship.
Already has?
There are students already were admitted under the new funding model.
So,
are the beneficiary
just a
of
minute.
the model that
I didn't get the point clearly. The second respondent?
Yes, Your Lordship. Your Lordship, third and first, second and third. In particular, the third respondent, a new model that has just been declared unconstitutional, Your Lordship.
Yes.
Resources have already been allocated, substantial resources, Your Lordship. And so, Your Lordship, if the judgment that has just been read is to take effect immediately, Your Lordship, first, second and third respondents will suffer substantial loss and also substantial loss. And even the students, Your Lordship, that have been admitted under the new model